Lights, camera, action, that's it. Lights, camera, action, that's it. Lights, camera, action, that's it. I look stellar tonight.
Hello, I'm Professor Adekile. Welcome to the Faculty of Law, University of Lagos channel. Today in the studio, we have some of our students who will be taking you through a case scenario in the law of tort. Please, as you watch, don't forget to like, comment, share, and subscribe to the channel. I'll hand over to the team lead, Ebenezer, to introduce his team members.
Thank you, Prof. I'm Tuvishedi Ebenezer Ayobami, the team lead. And with me here today are
Daniel Joy, 300 level law students.
Tuvel Jabu, 300 level law student.
Habib Onodipe, 300 level law student.
The green team, what do you have for us today?
So our question today borders on the topic of nuisance. So let's paint a picture. It is June 2025, and Lagoon State government has just partnered with a big energy company, Lekki Power Limited, to construct an independent energy product. Now, this seems all good on the surface, but because they're going to have 24/7 lights. But for someone like Chief Bello, who his house has always been his sanctuary, it is not all nice for him, because the advent of this construction has brought about, from 11 p.m. to 6 a.m., mechanical roars that disturb his nights, noxious gas, oily residues, peeling paint, coughing children, his asthmatic wife in distress, and tenants abandoning his boys' quarters. Property value has dropped, and all his complaints have been dismissed in the name of public good. So today we're going to ask the question: does Chief Bello and his family members have a claim under Nigerian law? And how can we balance progress with protection? So I want you to buckle up as we dissect this legal question.
Fantastic, quite interesting. So I would invite Habib to give us the issues that emanate from this case scenario.
Thank you very much, Prof. From the scenario, the issues arising from it are first, that who exactly can sue in the tort of private nuisance, and secondly, can Chief Bello bring an action in public nuisance? Who can be sued? And would also examine the defenses, likely defenses, and also the remedies. Thank you very much.
Thank you very much, Habib, for that perspective. Now I would invite Joy to give us an understanding of discussing these issues.
Thank you very much, Prof. So, according to Roma LJ, in the case of AG and PYA queries, he defined public nuisance as any act or omission which materially affects the reasonable comfort and convenience of life of a class of Her Majesty's subjects. So, public nuisance is normally the person that can bring an action under public nuisance is the AG of a federation or the states. Now, a private individual is not debarred from bringing an action so long as he can prove that he has suffered particular damage over and above that suffered by the general public, as seen in the case of Loins and Gulliver, as well as State and Lie against Greater London Council. Now, while under private nuisance, which was defined by Scott LJ, in the case of Reed and Loins, he defined private nuisance as an unlawful interference of a person's use and enjoyment of land or a right connected with land. Now, anyone that can sue under private nuisance must have a proprietary interest in that land, as was stated by Lord Simmons in the same case of Reed and Loins. Note that this interest could be legal, it could be an equitable interest, it could be statutory, or even one that has a reversionary interest in land, so long as it can prove that that nuisance will cause permanent injury to the land, and that right is coexistent with the right of the occupier. So basically, if you are a landlord, if you are the occupier of land, if you are the lessee, you can bring an action under private nuisance. But we should also bear in mind that family members, guests, lodgers cannot bring an action under private nuisance. And why? Simple, because they do not have an interest in land. Now, in the case of Maloney and Lasky, the wife of a tenant tried to bring an action, but her case could not fly because she did not have an interest in land. This was reaffirmed in the case of Hunter and Canary Wharf. So basically, under public nuisance, the AG brings an action or a private individual who can prove special damage, and under private nuisance, it's one who has an interest in land.
Thank you very much, Joy, for that deep analysis of the law. Before we go further, I would like to ask Tovia to give further insight into that perspective of public and private nuisance. Do you think, in the light of the facts, that we should lay emphasis on public nuisance?
So in light of the facts, we see that the focus should be on private nuisance, because all the damage that was done affects just Chief Bello and his family, and there is no question of whether it also affects the public. So taking off from there, I would also like to speak on who can actually be sued in this scenario. So generally, when it comes to the tort of nuisance, the creator of the nuisance can be sued. And then from the creator of the nuisance, it doesn't have to be the owner or the occupier of the land. Just whoever creates the nuisance can be sued. Then also the owner of the land can also be the person who is sued. And there are lots of scenarios where the owner of the land is also the defendant, but also the owner of the land might not even be the occupier of the land. In that situation, the owner of the land can still be liable under three conditions. We have where the owner of the land was aware of the problem before the occupier entered the land. Also a situation where it was the responsibility of the owner of the land to make sure that he takes control of the repairs that caused the nuisance, and a situation where it had been ratified between them in a contract. So those are the situations in which, even if there is a tenant who is there, the owner of the land will still be liable, can still be sued under the tort of nuisance. Aside from the owner of the land, you also have the controller of the hazard. Now, this was established in the case of Jones versus Portsmouth City Council. And in this case, what happened was that the Portsmouth City Council, they were supposed to be in charge of taking care of the shrubs and the trees of the defendants. And what happened there was that they did not do what they were supposed to do. And because of that, it led to a hazard on the land of the claimant. And the court said that since it was their duty to take control of it, they would be liable because they were supposed to control the hazard. So in that situation, even if they were not the occupiers or they were not the owners of the land, because they were in charge of controlling the hazard and it caused nuisance to the claimants, they were held liable by the courts. And then lastly, we also have the occupier of the land can be sued. So by occupier of the land, it can be the owner, but it might not be the owner. It could be a person who is a tenant. And under the rules of vicarious liability, a person who is the occupier of the land can be liable for nuisance that is created by third parties and also nuisance that is created by employers. But now there is an exception to that rule of vicarious liability. And that comes in where even if your employer is the one that created the nuisance, if what you had asked him to do was something that created a special hazardous situation, you will be held liable. And this was established by the case of Matania versus National Provincial Bank. And that was what the court held. Now, if we want to apply all these laws to the facts of our case, we see that it will be the occupier of the people who created the nuisance, that is Lekki Power Limited, that can be held liable. Because what they did, they are the people that can be sued, that Chief Bello can actually sue. But also we see that what they were told to do by the government was something that created a special hazardous situation, which means that not only can they be sued, but the government can be sued because they are the one who employed him. And in an exclusion to the rules of vicarious liability, that created a special hazardous situation.
Tovia, thank you very, very much. So I'm very glad that you are able to remember to apply the law to the specific facts before us by telling us the liability of the particular company in this case scenario. And we must always remember to do that at the end of her analysis. So now I would actually want to go to Ebenezer. I would like to go to Ebenezer to discuss the defenses that could be raised by these parties.
Thank you very much, Prof. When it comes to defenses that the defendant can raise in this case, I think there are two. Basically, he can raise statutory authority. He can also raise the utility of his act. So on the first one, on statutory authority, so this defense is actually invoked where the defendant maybe has obtained a planning authority, maybe from a particular regulatory agency or from a government authority. So the effect of a planning permission is that it serves to like change the nature or the character of a particular place. So, and we saw that play out in Gillingham Borough Council and Medway Saturn Dock. So in that case, what happened was that the defendant had actually obtained a planning permission to actually carry out some commercial activity in that area. So the continuous commercial activity that was carried out in that area, which actually affected the claimant in that case, was actually held by the court not to actually constitute nuisance because he had actually obtained a planning permission. So the defendant was not liable in that case. And the reason was that the effect of the, as actually enunciated by the court, the effect of the planning permission was to change the character of the whole environment. However, we saw that in the case of Wheeler and J.J. Saunders, the reverse was the case, because in this case, the defendant had actually obtained the planning permission to carry out pig farming in a particular area. And then the odor, the strong smell and odor from his pig farm actually affected the claimant. So the claimant sued, and the defendant actually relied on the planning permission which he had obtained to actually absolve himself of liability. And the court held that no, that he could not rely on the planning permission. Why? Because the planning permission in that case did not change the nature of the environment. The implication is that where there is a planning permission, the effect of planning permission is to actually change the nature of the locality such that the activity carried out in that particular locality is majorly that particular activity. So like we saw in Gillingham, the place eventually became like a highly industrialized and commercial arena. Meanwhile, in J.J. Saunders, the environment or the area did not become majorly a pig farm. So in that case, it did not change the nature of the environment. The defendant was actually liable. So in this case now, the activity that was carried out by Lekki Power Works did not change the nature of the environment, so they will not be able to sufficiently rely on the defense of statutory authority. Now, on the issue of the utility of their conduct or the utility of their act, now in that case, there was Lekki Power Works was saying that okay, that their work was actually beneficial to the locality, to the environment. But then judicial decisions have pronounced that regardless of the benefit that the environment actually derive from your activities, you could still be liable for committing nuisance. And we saw that in the Australian case of Bellew and Cement Company. So in that case, despite the fact that it was the only cement factory, it's an Ireland case. So despite the fact that it was the only cement company in the country at the time, they were still held liable because the manufacturing of cement, was actually constituted nuisance to the residents of the area. Now, let me just point out that Lord Gough in Cambridge Water and Eastern Leicester counties warned that we should not be we should not be carried away by the utility of the defendant's conduct. He mentioned that regardless of the fact that Eastern Leicester counties, their activities provided employment for the residents of the community does not mean that whatever they were doing was not hazardous. So in that case, he held them liable for the hazard, for the hazard, for the hazard of their activity, and even the chemical that is stored on their premises. He held it to constitute a non-natural user, although that applies to the rule in Anaflesia, but then it relates to the thought of nuisance. And so we should not get carried away in this case by the fact that Lekki Power Works, actually their work is benefiting the environment. So in this case, they can rely on these two defenses, but the extent to which it can actually avail them is very, very slim on those decided cases. So I think they can actually raise these defenses, but the extent to which it can avail them is very, very slim. Thank you very much, Prof.
Thank you. Thank you very much, Ebenezer. Very, very interesting. So Ebenezer has discussed some of the defenses available in nuisance. He's spoken about planning authority. He's talked about utility of the defendant's conduct, and it's linked with the issue of, and I would like to introduce this perspective, the authority, this issue of statutory authority, because if you look at the facts of that question, within the time that is allotted for exams, you should make sure that you focus a lot on the issue of utility of the defendant's conduct and discussion of that perspective. But I like that very thorough analysis of planning authority. When you're coming to the question of statutory authority too, you must note that statutes are strictly construed, and that when they are analyzing the facts of the case, the court would like to look at exactly what you are being empowered to do by that statute, and you are strictly liable to limit yourself to what the statute has empowered you to do. I'll also now go to who should I take next? I think I should take Abib to discuss the remedies that may be available.
Thank you, Ma. So the remedies for in the available in the question, the first is that the Chief Bello can get a declaratory relief from the court to affirm that a nuisance truly exists. That's the first one. Then the second would be definitely damages. So because from the question, from the case scenario, there has been a reduction in the value of his property, and as the tenant living in his boys' quarters had left, even some other damages that he has suffered, injuries that he has suffered, I mean. So you could request damages. Then the last remedy available to Chief Bello is injunction to stop the continuance of that nuisance by Lekki Power Works. So, and we can see this in the cases of Sturgis and Bridgman. And Ebenezer mentioned something about injunction. That's the case of Bellew and Cement Co. That if the company perpetrating in the nuisance is producing or doing in business that serves the public good of the company or what the company is doing, would stop the awardance of injunction. So we can say that no, because every human being in the society are equal. So the fact that the court would consider your own injury, because look at everything Chief Bello has suffered. So it will be unjust for the court to deny Chief Bello injunction, because this would definitely lead to the continuance of the nuisance in the vicinity where Chief Bello lives. Thank you.
Okay. Thank you very much, Habib. So Habib has spoken about the remedies, because the essence of going to court is that you should be able to get remedies in real life. So he's spoken about the damages, he's spoken about injunction. I would invite Joy to give final thoughts on this case scenario. Is there something you would like to add to what your colleagues have discussed?
Thank you, ma'am. So really, they've spoke at length and they've covered everything. But looking beyond the thoughts, this is actually an environmental injustice. So Section 20 of the 1999 Constitution, as amended, the Nestria Acts, as well as the public health laws of different states in Nigeria, obligate the government to protect the environment. But here we see public policy choking the very citizens that they claim to protect. So, tort law, specifically nuisance, also in a way interlaps with environmental law, and this can actually be a great way of enforcing environmental rights by both the individual and even the government. Thank you.
Wow. Joy, thank you very much. So she has introduced the perspective of the environment. And you'd recall that one of the things that you are taught as a tort student is to look at the interests that a tort protects. Okay, and one of the things that interests that the tort of nuisance protects is environment, the environmental rights. So I like that perspective as well, and you can, dig deeper into that. But for purposes of examinations, I'm sure you know, as students of the law of tort, you are supposed to limit yourselves to just the discussion of the tort aspect in terms of liabilities and what have you. So finally, I would like to say that this case scenario, of course, has made you to look through the whole gamut of the principles of the tort of nuisance. And with that perspective, you know that in the exam context, you must learn to manage your time by limiting yourself strictly to the case scenario. Thank you very much to Team Green for leading this discussion, and I believe that you'll be back to give us another case scenario in the law of tort or in any other area of the law of interest. Thank you. See you at the next presentation.
Lights, camera, action, that's it.